Good day, and welcome to the Patently Strategic Podcast, where we discuss all things at the intersection of business, technology, and patents. This podcast is a monthly discussion amongst experts in the field of patenting. It is for inventors, founders, and IP professionals alike, established or aspiring. And in this month's episode, we depart from our normal format into a deep dive style investigative documentary into why these good folks gathered to demonstrate in front of regional USPTO offices all across the country on the 10-year anniversary of the passage of the America Invents Act. The voices you heard are those of inventors who unfortunately found themselves on the receiving end of the unintended consequences of the America Invents Act and its most unfortunate progeny, the PTAB, or Patent Trial and Appeal Board. It's eerily fitting that we're covering this topic in our Halloween episode. The PTAB has another name. Among the inventor community, it is far less affectionately referred to as the Patent Death Squad. The mere mention of it will send chills down the spines of most inventors. It should come accompanied by a compulsory maniacal laugh, backed by an ominous thunderclap. With an estimated patent invalidation rate of 84%, this group delivers far more tricks than treats for unsuspecting inventors. You heard that right. No need to rewind. According to US Inventor, 84% of granted patents that once went through a rigorous process of examination that come up for challenge in front of the PTAB are invalidated. Invalidated by the sibling division of the same patent office that previously issued the patent. The inventors and entrepreneurs at the rally we attended, and countless others like them in cities all across the country, all from diverse backgrounds with different stories, all have one thing in common, and that is their shared belief that the AIA has crippled innovators and created a decade of stolen dreams, ruining the lives of countless inventors and shutting down numerous startups in favor of big tech and multinational corporations. Inventors are not only the real engine of our economy, but they're also the reason why we do what we do here at Aurora. This is a complex issue with high stakes involving the people who matter most to our business and what the world will look like for our kids. So we can't think of a better use of a podcast episode than to lend a voice and hopefully shine a light on the key issues and some potential solutions. We're going to break this down and look at it through a wide array of personal perspectives from inventors, patent practitioners, and even a former USPTO patent examiner. In researching this topic and talking with so many impacted individuals, it became clear that there's a very big picture missing from all of its coverage. And that picture only comes into focus when you bring these perspectives together. In addition to perspective, we first need some context. Before we dig more into the PTAB and these rallies, it's important to zoom out, travel back in time to 2011, take a moment to first understand broadly what the AIA introduced, perhaps for better and for worse. For that, I sat down with Ashley Sloat, President and Director of Patent Strategy here at Aurora. So Ashley, I know this could be a huge topic of its own, but could you, at a high-level, lightning round fashion, explain what the AIA is, what its goal was, and how it changed patent law?
On September 16, 2011, the Leahy-Smith America Invents Act, also known as AIA or the Patent Reform Act of 2011, was signed into law with the stated goal of modernizing America's patent laws and harmonizing the U.S. with the rest of the world. It's certainly one of the biggest changes to U.S. patent law in the past half century. So the biggest change, probably, I guess, in the minds of many listeners, is that the AIA switched the U.S. patent system from a first-to-invent system to a first-inventor-to-file system, which largely aligns the United States with the rest of the world. Under this new system, the date the patent application is filed with the Patent Office instead of the actual date of invention in your notebook determines who wins the race to patent the invention. This means that the practice of mailing your invention, which I know many of you did, to yourself so that it has the postmark date to prove invention date, this practice no longer applies. As a result of AIA becoming the law of the land, we heavily encourage inventors to file early and often. You can do a provisional patent application, which only pens for 1 year, and that application can then later be converted to a full U.S. patent application or international patent application. Another item that changed was prior art types for public uses or sales. The AIA also redefined the types of activities that may be used to reject a patent application. For example, under pre-AIA law, a public use or sale of a claimed invention prior to patent application filing was only considered problematic activity if it occurred in the United States, and then this activity could be used to reject your patent application. However, under the AIA, public use or sale anywhere in the world, not just the U.S., could prevent later patenting. Another provision that changed with AIA was assignee filing. Under pre-AIA, only inventors could apply for a patent. Under the AIA, an applicant, for example, a company as the owner or assignee of an invention, may file a patent application on behalf of the inventors. During the patent application process, an inventor is still required to execute a declaration indicating that she indeed was an inventor, but this can be bypassed by the applicant in various situations. Furthermore, regional patent offices are now open as a result of AIA. These regional offices include places such as Dallas, Denver, Detroit, and San Jose. Prioritized examination was also made available as a result of AIA. Prioritized examination, also known as Track 1, allows inventors to accelerate the examination of selected patent applications through payment of an extra fee to the patent office. Another change that was brought about by AIA was that the PTO is now in charge of its revenue. So the AIA gave the PTO the ability to set its own fees and create an operating reserve. We should all breathe a big sigh of relief since the USPTO is finally able to invest in much needed information technology upgrades, hire more examiners, and provide additional examiner training. And lastly, and of course, a significant subject of discussion for this podcast is that it also brought about the PTAB and IPRs, which enables granted patents to be challenged by members of the public. This gave birth to the Patent Trial and Appeal Board, or the PTAB, to oversee all post-grant proceedings, replacing its predecessor, the Board of Patent Appeals and Interferences.
Okay, so definitely some positives and needed changes in there, but PTAB. There's that word again. The PTAB was created with the goals of providing a faster and less costly alternative to court-based patent infringement suits, weeding out patents that shouldn't have been issued in the first place, and reducing the amount of patent litigation brought on by patent troll syndrome. This was to be accomplished via an AIA-introduced process called Inter-Parties Review, or IPR, in which granted patents can be challenged by any member of the public, most likely coming from a patent owner's competitor or defensively by someone being sued for infringement. In theory, this all sounds constructive. But as they say, the difference between in practice and in theory is often far greater in practice than in theory. So why do inventor advocacy groups refer to the passage of the AIA as the worst event in history for American inventors? According to Josh Malone, policy director at US Inventor, the org that sponsors these rallies, quote, "The PTAB was sold to Congress as an easier, faster, and fair alternative to litigation for patent disputes. However, what it became instead was a powerful tool that a large infringer could use to challenge the validity of any small inventor's patent in order to use the inventor's technology royalty-free, or to prevent the inventor's disruptive technology from competing in the marketplace." We spoke with Dan Brown about this at the rally in Detroit. Every space shuttle that's ever gone up has used a technology process he created. Dan is the owner of 40 utility patents, including the bionic wrench, was elected to the National Academy of Inventors, and is serving as the inventor rep on the Patent Public Advisory Council working with the Patent Office. Suffice it to say, Dan has some skin in the game.
I think fundamentally the AIA had a number of things in there, harmonizing the 20 years, and there were a lot of things that the Patent Office put into place. But the biggest problem is the PTAB and the lack of due process at the PTAB and the David and Goliath situation we have in this predatory infringement process, where the PTAB was supposedly supposed to make it easier and less costly to litigate for small inventors. It gave the infringers more arrows in their quiver to go after them, and it's totally unintended consequences, and people recognize that now. So Congress has to stop this infringement business model.
This is all happening with great lethal efficiency. According to US Inventor, as of June 24th of this year, the PTAB has invalidated 84% of the 3,105 challenged patents that it has received. The PTAB has become a powerful anti-competitive tool for large companies, the same companies that as small, innovative startups use the patent system to change the world. Companies like Apple, Google, and Microsoft top the list of PTAB challengers. These companies have massive political clout, and whether intended or not, AIA is being wielded with the effect of a deeply protectionist law. We spoke with Bob Schmidt about this. Bob is the co-chair of the Small Business Technology Council. He's built 5 companies and has 40 patents to his name.
This is very simple. These are the lessons that one learns in elementary school. The reason you build your clubhouse up in a tree is you can have the rope ladder that you can pull it up so the little kids and the girls can't come up. And that's what the America Invents Act is all about. It's big tech that went through this themselves, protected themselves with a patent, but now they want to make sure nobody else comes along and boots them out.
The net effect is a clear path to endorsed piracy by using the Patent Office against inventors.
We have this cannibalistic system that as soon as a competitive advantage arises from one of our designs, the pirates sweep in and steal your patent and put you into a meat grinder that requires a tremendous amount of money because it's a David and Goliath battle, and it's just not fair at all. There's no justice in this justice system.
So what about the stated legislative goal of weeding out bad patents that shouldn't have been issued in the first place?
The reality is we have this concept of obviousness that kills patents. And I believe right now the obviousness at the patent office to get a patent, which is tough. It's not easy to get a patent. I've been going back and forth for years, and those examiners are tough. That same process to get it, once you get it, is a different one that's being used when they take them away. Now, that doesn't make any sense to me. We have this hypocrisy or this schizophrenic organization that's giving patents and taking them away. Now, the PTAB was created to get away from patents that were bad patents. And I'll tell you, there are some bad patents out there. We would be foolish not to acknowledge that. But the system has been gamed so that they're using that same system to take good patents away. For me, and if you get into the weeds on intellectual property, the grade factors, our secondary considerations for obviousness, if you get a product in the market and it has success, I think by definition that was not obvious because it would have been in the marketplace before. But now at the PTAB, they're creating these obviousness objections by going back and finding other art, and it's called hindsight reconstruction bias, making these arguments that you should lose it, even though these products had gone in the market and competed and won. Makes no sense to me, and we need to reconcile that.
We'll tackle the difficulty of getting a patent in just a bit, but it's worth underscoring that in practice, herd thinning is not what's happening. Instead, IPRs in the PTAB are being used to invalidate some of the best U.S. patents. The answer of why this is happening is simple economics. The cost to file and prosecute an IPR is averaging around $500,000. What company could possibly afford or justify that cost for anything but against a significant competitive threat? Data published on Professor Dennis Crouch's Patently.io shows that most patents tangled up in IPRs are also involved in litigation or licensing. Patents involved in litigation or licensing are considered top-tier patents and make up only a very small percentage of granted patents. Back to our inventors. While in Detroit, we also learned that the power and leverage of the PTAB extends well beyond just the decisions of its judges. More on them in a bit. The mere threat of being IPR'd and the crushing costs that come with it are enough to extinguish the licensing dreams and patent assertion rights of many inventors. Because like Bob says,
why pay for it? You can just steal it. And so that's what they do.
When you attempt to stop a large corporation from infringing your patent or attempt to license it to them, they often instead try to use the PTAB to invalidate the patent. We also had the pleasure of speaking with Kip Azzoni Doyle at the Detroit Rally. Kip is the inventor of the Card Shark wallet skin and the author of the upcoming book, Blood in the Water, America's Assault on Innovation. Listen in as Kip shares her chilling experience.
So for me, I watched, it was like I was on the sideline watching my own parade go by as all these infringers have been infringing blatantly or efficiently my patents. So every single time I find an infringer, I have to alert my team, and then we have to do a very delicate dance of cease and desist so that we don't get IPR'd, because the minute that happens, it's over. And so it's affected me terribly. I mean, I've left hundreds of thousands, if not millions, on the table because I've been told, if you pursue me, if you pursue our company, we'll IPR you, because we'll never spend the money on a license from you, little inventor. We'll spend the money on the IPR so that you're out of the game.
So have you had any direct experience with the PTAB, or has it been largely trying to avoid it?
For me, it's been largely trying to avoid it. However, I've had every form of threat you can imagine. I was threatened with an IPR by a very powerful guy who was his wife owned the company. He is a big head of a studio out in LA, and he just has all the money in the world, and he just said, oh, no. And he came over and ripped my patents and said, I will IPR you before I spend a dime. So.
Let's talk for a second about the financial impact of being on the receiving end of an IPR. According to the American Institute of Patent Law Association, a patent defense at the PTAB will cost from $400,000 to $800,000. This is still less expensive than the district court-based journey, but unfortunately, a single patent can have many IPRs filed against it, each costing that amount. We mentioned Josh Malone earlier. Before helping to lead the charge at US Inventor, he invented a bunch of balloons. His Kickstarter campaign went viral and made him a large target for infringement. Not long after becoming a summer toy hit, Josh found out his invention was being ripped off and sold by a serial infringer. After obtaining multiple injunctions against the infringer changed course and decided to file an IPR against Josh with the PTAB. Without due process, Josh's patents were revoked. His patent rights were invalidated at the hands of the company stealing and profiting from his idea. Fortunately for Josh, he filed suit, won, and his rights were restored. But along the way, he spent millions in legal fees, having to raise and spend $75,000 every week, hiring 6 different law firms, 3 different technical experts, and 29 different attorneys. In fully understanding the scope of the problem, it's important to take a closer look at the PTAB itself. Much like we'll do with the examination process in a bit, we want to peel the curtain back on the PTAB, discuss its composition, and how it differs with traditional court-based litigation. The PTAB tribunal consists of a panel of administrative patent judges, or APJs. Once an IPR is granted, the judges are required to submit an opinion on validity within 1 year. This requirement aims to fulfill AIA's promise of an expedited alternative to the courts. Prior to AIA, patent validity issues within the context of infringement suits were settled exclusively by Article III federal courts. It's now possible to have disputes flow through either or both. That said, the PTAB is now seen as a more favorable venue to challenging patents for a handful of reasons. First, there's probability. There's a widely held belief, backed up by an ever-increasing data set, that PTAB judges are far more likely to invalidate patents than juries. Second, there's a significantly reduced burden of proof. In district courts, patents are assumed valid and challengers must prove that each claim is invalid using clear and convincing evidence. This requires the challenger to present the highest possible burden of proof in civil litigation. This presumption of validity does not exist in the PTAB, and challengers must only establish that it is more likely than not that the claims are unpatentable. Third, PTAB claim construction is broader. This allows PTAB cases to sweep in more prior art, leading to increased invalidation decisions based on obviousness. Fourth, standing is not required to file an IPR. In Article III district courts, a party must have sufficient standing to bring about a suit. With the PTAB, any member of the public may initiate an IPR. And then there are the judges themselves. For the most part, the APJs are attorneys with legal backgrounds, often lacking education and experience around the scientific and technical matters they're ruling on. According to US Inventor, 60% of APJs have 0 technical experience, and 76% have less than 3 years of technical experience. Despite having tremendous power and authority, they are also far less experienced on average than their federal surrogate counterparts, based on a study conducted by Gene Quinn of IP Watchdog. For example, the study found that many judges were appointed to the PTAB at a time when they were still associates or even junior associates, and that there were 0 federal district court judges appointed with 10 years or less experience, while 47% of PTAB judges were appointed with 10 years experience or less. So there you have it. Inexperienced lawyers with little technical background overturning patents that may have gone through years of rigorous examination by individuals with relevant backgrounds. How could this possibly go wrong? The first step is always admitting you have a problem. That box has been firmly checked. But before we pivot into possible solutions, it's important to consider the cost of doing nothing. For this, we return to some of our inventor friends in Detroit. Unfortunately, it's been a decade, and that's plenty of time to see measurable effect.
What matters? Well, what matters is since the American Invents Act passed, we went from number 1 in innovation to number 11 in innovation in the world. So America has just plummeted and it keeps falling.
And this, of course, creates ripple effects throughout the entire economy.
I do this because I believe inventors create jobs, and I believe the best social system is a good job. And from that perspective, that if we don't have a patent system where people can count on the value of their patents so they can raise money, bring products to market, no one's going to bring products out in the States, because you end up just getting slain. And there's no government program to save you after you've lost all the money you invested.
And how about the impact on the value of patents?
So I just came up with this idea, kept quiet, and managed to get some patents around it. But I stepped into this world right when the AIA, the American Invents Act, became a thing, and so it stripped the value of the patents. I had these patents, and I was all excited to go out and, first of all, I'd spend every penny I had to get the patents, thinking, okay, now I can either sell my portfolio. I had 3, which was very small, but they were 3 patents in a specific space, so I thought, well, I'm going to go sell it to a company that can really knock this out of the park. But unfortunately, it was at the time when these changes were occurring, so nobody was interested in buying patents. Nobody was interested in even licensing them.
Which of course has a measured effect of its own.
For the Chicagoans here, how many of you have heard of Ocean Tomo? Anybody from Chicago? Okay, so a couple at least. So, these are the big name guys that, do the reports on what patents are worth, and they've shown the American Invents Act cut the value of a patent by 2/3. So, 10 years ago, a patent, typically the rule of thumb, stick up your thumb, it's worth $1 million. That can be off by an order of magnitude either way, but roughly $1 million. And so now it's a third of that.
And in case you missed it, Louis Carbonell weighed in on this from a patent brokerage perspective in last month's episode on monetization.
If you look back about 10, 12 years ago, you had a lot of demand for patents. It was considered to be the next kind of commercial weapon. That was kind of the golden age or golden era of patent monetization. And unfortunately, that's when I started. So I missed all of that. The 5 years before that had been great for anyone who was buying or selling patents. Then after 2012, it came to a screeching halt, essentially. I think people realized that, they were overpaying for assets that, were sometimes not that, clear in terms of what they meant or what they encompassed. And then, the case law changed. We had Bilski and we had Alice, and we're still living with the aftermath of Alice and its progeny. In parallel, we have the AIA, American Invents Act, which really threw monkey wrench in the gears because suddenly people discovered that IPRs were the new way to invalidate patents, and it kind of took on a life of its own. So all these things contributed to a very different marketplace today than what we had 7, 8, 10 years ago.
Analysis of patent transaction data shows that the combined effect of this devaluation comes at over $1 trillion cost to the overall U.S. economy. The ultimate cost, however, is far greater than purely financial. A country's greatest assets are its people and their ideas. When the accepted consensus is that you can no longer protect your ideas and investments from theft, then who's going to innovate? The best you can hope for at this point is a copycat race to the bottom. This is a fundamental question about property rights, and as many inventors will tell you, those rights are among the oldest and most important.
One of the things that we want to talk about is the Article 1, Section 8, Clause 8 of giving rights to authors and inventors. How many times is the word right used in the Constitution? Who knows? There's an answer. That's right. Once. And it's capitalized. And the only time the word right is used is with regard to inventors and authors. So it predated, guns, religion, freedom to assemble, all of the other rights in the Bill of Rights by 3 years.
So what exactly is Article 1, Section 8? The notion of intellectual property rights in America is as old as, America. Those rights are spelled out in Article 1, Section 8, Clause 8 of the U.S. Constitution, ratified on September 17, 1787. This clause grants Congress the power to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. The framers believed in the importance of protecting intellectual property rights, and for a couple hundred years, the U.S. has led the world in innovation, in large part due to the protections provided to inventors and their investments through our patent system. The integrity of the system and the fulfillment of its promise are essential ingredients to the American dream. An IPR is basically a request for the patent office to admit they made a mistake in issuing a patent, a property right. Based on faith in the initial decision and perceived ownership of that property, the inventor has since relied on that original decision to build a business, take investment, and initiate licensing discussions. The inventor paid for that property up front and continued to pay maintenance fees to retain ownership. And then, the decision is reversed by the PTAB, and the property right upon which everything else was built, poof, vanishes from underneath. The way we currently deal with intellectual property rights has become so far disconnected from how we think about other property rights. Louis Carbonell really drove this point home in last month's episode as well.
It's as basic as that. Is that try to buy some land if you're not sure that you actually have the right to build something on it. It's and the city can tell you. They'll say, well, build something and we'll tell you if we can issue a permit, but you have to build first. That's a little bit the kind of irony we have with patents. You have to get them first, pay, I don't know, the average I think is $50,000-$60,000 according to the latest surveys I've seen for a single patent, overall, including maintenance fees and all this, just to get a patent. And then you have to pay another $250,000 for the PTAB to tell you whether it was, it was crap from day one or it was actually valid. Which, if you think about it and you stop for a second, what industry could survive with a business model like this, where you have to buy the thing and then you have to pay 5 times more than you paid for the first time just to be told whether you can use it or not?
Okay, so now what can we do about it? The default instinct around legislative problems tends to be more legislation. The Stronger Patents Act seems to get dusted off every few years. US Inventor helped introduce the Inventor Rights Act of 2019, and there's a new legislative proposal on US Inventor right now. Senators Leahy and Cornyn recently introduced the Restoring the America Invents Act. Patently O describes as a, quote, wish list for patent killers seeking to cancel patent rights via inter-parties review. That's clearly not the answer, but what would meaningful reform truly look like?
Sure, throw out American Invents Act, throw out all of the cases from the Supreme Court, and go back to where we were, 20 years ago. That's what true meaningful reform would be, and that's what built America. We had all of these, 226 years or whatever it is now, of using the Constitution and building on patents and creating innovation in America, and now all of a sudden we don't, because we're just not protecting or helping inventors.
Yeah. So just even repealing AIA would be a really good start?
That would be a good start, but that's not going to happen. This is big tech, big money, and, it's not going to happen. So it's got to be in tiny little bits of, just a small step here, a small step there over decades. That's what we're going to see.
What would be the 1 to 3 most meaningful steps?
Well, I think Director Iancu did wonderful work at the Patent Office. And so the Biden choice of who's going to be the patent director is going to be huge. Is he going to get a Michelle Lee or a Andre Iancu to be the next leader? And Michelle did everything she could to make sure that little companies can't survive or don't survive, whereas Iancu was really helping us. And so be able to do that, to be able to limit the scope of the PTAB, of how do you make sure they don't initiate programs unless it's, really needed, and then to make sure that it's validated with what they do, to take away the bonuses for people and the incentives for PTAB judges to be able to throw all these cases out. I mean, that's just horrible. And, I think we're mostly beyond what Michelle Lee was doing of having, stacking the court, if you will. First there were 3 and she didn't like their decision, so she added several others and then others and others until finally she got a decision she wanted. And that's just, that's not American. So we've got to improve that.
Now, one thing I hear floated around a lot, I know it doesn't seem like it's getting a lot of traction, and it seems like there have been N versions of these things that kind of pop up and die is the Stronger Patents Act.
Yeah.
What's the high level synopsis on that? Do we believe that's a good thing? Does that in whatever its most recent flavor is?
Well, it hasn't changed a lot for the last 4 years.
Okay.
And it's just, for right now, it's non-existent because there is no Stronger Patents Act. We lost Stivers, who took it up in the House a couple of years ago, and he decided to get out of the House and go run the Chamber of Commerce in Ohio. So there's nobody there that's picked it up in the House, and I think Coons has looked at this, and he's been our hero. Senator Coons and Senator Hirono have just been wonderful for us, but there just wasn't enough votes to be able to get it on. And now with Darrell Issa coming back in the House, that's not helping because he was one of the major proponents of the American Invents Act. So he's not been helpful. So until we can change those people's minds of the fact that this has been a disaster, and eventually, big tech will understand that this is not in their best interest. It's in their short-term interest for protecting their bonus for a number of years. But what happens when America can't compete anymore and the Americans aren't, using the Googles and the Apples of the world, but we're going on and using the Chinese products instead because Americans don't have the money to do it. Now we're still more than a decade, probably 2 decades or more away from that happening, but eventually it will happen. But the problem is, how do they turn it around at that point?
Despite all of the talk around legislative fixes for the AIA, there was one stat I just couldn't shake. Even district courts invalidate patents at a rate of about 40%. That's not near the fatality rate dealt by the PTAB, but it's still a surprisingly large number. Put another way, when challenged at a district court, a little less than half of what comes out of the PTO is later reversed. Many of the proposed legislative solutions don't appear to hit the problem at its root, which is ultimately invalidation. Any reform related to post-grant proceedings is missing the bigger issue. Post-grant proceedings could be incredibly rare in a world where PTO examiner decisions were more binding than they presently are. In a more ideal world, it seems like we should get to a point where the determination made by the examiner was closer to something binding, with invalidations being an extreme exception versus 40% in district courts and 84% in the PTAB. Any other system essentially leaves you with a patent pending indefinitely until expired or tested by courts. At some level of scale, are patents getting through the patent office that shouldn't be? Or is there some other disconnect in the schizophrenic system that is both granting and later taking away? One theory often stated is that examiners simply aren't granted enough time to adequately search prior art or understand the domain at the depth required. To get an inside the PTO perspective on this theory, we sat down with former examiner and current practitioner Tariq Najila. During his 10 years as a patent examiner at the USPTO, Tariq specialized in electrical engineering technologies, including telecommunications, digital communications, computer networking, cryptography, and storage area networks.
Okay, Tariq. So first question, from the outside, the examination process feels like a bit of a black box. So at a very high level, could you walk me through the process of examination once an application leaves an inventor's hands and gets submitted to the PTO?
So if you look at the 30,000 foot level, patent examination, it follows the manual of patent examining procedure, 100%. So application is submitted, it goes to the receiving office or to the application processing unit, where all the, let's say, the formalities of submission are checked over. If you've ever gotten a notice of incomplete application or missing parts, that's not done by an examiner. That's done by the application receiving office or processing unit. They're going to check over the formalities. And once you meet the formalities, then it's docketed. It'll go to a master docket to be assigned, usually through some type of algorithm, to a art unit or technology center, then an art unit. And then at some point in the future, if it's prioritized examination is almost instant. You get assigned an examiner. If it's not prioritized and you're looking at just, whenever it comes up, for the time of its entry, you'll get assigned an examiner. Once you're assigned an examiner, it goes in the examiner's docket. The examiner gets it on the docket. And when it comes up for time, they will search they'll read the disclosure. Again, as per the MPEP, the Manual for Patent Examining Procedure, they will read the disclosure, read the claims, understand the invention. Once they have an understanding of the invention, and they can kind of diagram the claims to understand how the claims relate to the invention, they will do a prior art search. If they need help with that search, they reach out to additional resources in the patent office to get help. Then they will, once they have done an exhaustive search, they'll draft an office action. If they're a junior examiner, they'll submit their office action to be reviewed by their primary or supervisory patent examiner, SPE, send it to them, get it approved. If they're not a junior examiner, they just sign it and send it out. It'll go out in the mail. You receive an office action or allowance, whatever it's rendered. So the first thing is to do the prior art search and then apply the statutes as well while they're doing their reading of the claims and reading of the disclosure. They're applying the statutes at minimum, 101, 112, 102, 103 at a minimum. But usually more than that. There's many more statutes than that they have to apply. But they go through that entire process, examine the application, and then render the office action. And that continues the process until, the prosecution, go back and forth till you arrive at some kind of outcome, whether that's allowance, abandonment, appeal, whatever the outcome is, petition, any type of outcome. That's what happens.
So it can take 2 years or more to get a granted patent, but from the time that the patent application hits your desk as an examiner to the point of being issued or a final rejection, on average, how many hours is that application actually your focus? Just really want to try to give folks a sense of, I hear a lot about, they had my patent application for 2 years. Well, no, it didn't it sat in a file, like digital or otherwise for 2 years, but that's not how long it was actually looked at. There's queue time and there's actual examination time. What's actual examination time?
So there's queue time and, that's waiting. The average queue time is 24 months, according to the Patent Office statistic. The average time for patent, once you come up in the queue, is usually about 12 to 18 months. So once you actually start working on it, now most of that time too is back and forth. So when they they examine it and give you the office action or you get a restriction, whatever you get in the beginning, let's say they're spending, whatever the allotted time is, let's say 4 to 20 hours or something like that, depending on what type of art it is. Because they're experts and they see the same type of applications every day, they're just looking for the nuances. Is this novel or not? Is this obvious or not? Trust of examiners looking at they're looking at 100 applications a year and they're all in the same technology. They can look at your application and say, okay, let me read this. Okay, I got it. I've seen this before because I just did this last week, yesterday. So they don't have to spend 40 hours on your application to understand it because they're doing the same thing over and over again. So they are experts of the process and hopefully experts of your technology area in terms of what's patentable. They may not be experts in the sense that the applicant's an expert as an inventor, but in terms of processing what's novel, they know what they've seen, they know what they hadn't seen. And so, let's say between 4 and 30 hours on an office action, right? That office action goes out. You have 3 months to respond. You can extend it up to 3 months. So that process, that waiting time can be 3 to 6 months. If you shorten that waiting time to 1 month, then we're at a different kind of. You can compact the time. It's called compact prosecution. You can make it go much faster. So that happens, let's say 2 rounds. So they send you the office action, you have 3 to 6 months. You send back to them, they have 3 to 6 months, pretty much. It goes round robin, back and forth until you get to either, disposition or RC or whatever it is that you're looking for.
So if we did compress out simply all of the back and forth time, and instead looked at just the amount of time you spent working on a particular invention, a particular application over the course of the time from it hits your desk until final issuance to rejection, and I know that's going to be highly situationally dependent. Any broad sense of a range of the amount of time you might spend with any given invention?
I would say that varies by examiner. Like in my art unit, I had 20 plus hours to work on an application. I spent 20 plus hours on every application every time. So if we did 4 rounds of prosecution, that's two office actions, RCE, another 2 office actions, and there are interviews in between there. That's more time. So let's say that's 25. And maybe they filed an after final on each one. And I called for an examiner's amendment. That's easily 100 hours plus that I spent on an application. that's me. I could, I know other examiners that were very efficient and had different ways they did things that they rarely spent that much time on an application, but it doesn't mean that they were spending, it was less quality. They could have been better than me. They could have been getting more allowances and it could have been faster. So what I'm dealing with is, you're dealing with aptitude, you're dealing with comprehension, speed of comprehension, complex information, processing, doing comparisons and analysis. There's no one metric that I could give that would say this is how much time is given. And even given that kind of metric is not fair. I would just say that know that you have had very focused, dedicated amounts of time given to your application at each and every stage of the process. That's all I could say. I couldn't say what the number is. I don't know.
But I mean, if you spend 100 hours total on one, nobody's breathing down your neck and saying you got to move these along.
No, that never happened. There was never hurry along just to get it done, or because it always comes back to you. So as an examiner, you never escape it. Like you can't do an application, office action that's trash, and it all comes back to you. It's going to come back to you in a write-up. It's going to come back to you in extra trainings because you have errors, warnings for, messing up, you're not applying statutes. It's going to come back in complaints. Going to have the inventors going to call the director. I'm just saying that these are all things that examiners experience and happen. There's no, it's just say, just go ahead and hurry up along. We just need to get these out. That's not part of it. No.
Talking a little bit about prior art, what percentage of your time would you say was spent on prior art searches? Majority. And was there ever any pressure to spend less or more time on prior art search?
No, I think so. I think that's really what the job of the examiner is. Like you said, we're preserving, looking at the law to preserve useful arts. You do that by making sure that this is something that's novel and non-obvious. That's the practical way. The statutes, that's what the statutes are applying. I mean, the formal statutes of 101, let the courts litigate that. We don't really care. We follow the checklist. You say it's statutory, we say, okay, we follow the checklist. If it says yes, then yes. If it says no, we say no. We put the boilerplate language in there. We don't really have any decision on that. We just apply what the law says. 112, those are very specific. Those, we apply those based on what the law says. Those are checklists and things we have to go through. If we go through them and they result in a rejection, that's because this language is here. It necessitates this rejection. What we're really there to interpret, what we're really there to understand is understand the invention and apply 102 and 103. That's really where the meat of it is. That's what you care about. Is somebody are you infringing somebody or is somebody infringing you? That's what you want to know. That's what that's why the primary job of the examiner is to search. That's the fundamental, at least when I was there for the 10 years I was there, that was the fundamental focus of what we did.
I've heard claims that the search tools that are available within the PTO are heavily U.S. specific and might not necessarily include access to academic journals. True, false, urban legend?
False.
False.
Urban legend.
Okay.
There's multiple tools. Now, the tools that we use in the patent office, you can't use. That is true. Like when I'm at the patent office, I can search unpublished patents. So I have access to unexamined things that are in the queue, but I can search them. They're part of my search. They're not part of your search database because I can search provisionals. You can't search provisionals. I can search. So I have more swaths of data, and within those databases includes foreign patents. Plus, we have other softwares that focus specifically on foreign patents. There's patent search software. There's also academic search software with their patent office has its own, I was in computing, so we had IEEE. I can't think of all of them right now. We had tons of databases of all the engineering and science journals, and we had to search all that stuff. You can't just search the patents. You have to search everything. And so that's just not true. That's not true. And now you can have a bad examiner that they're probably going to get fired if they don't search outside of patents. Excuse me. But yeah, that's the urban legend. It's not, I would say there's no real truth to that.
All right. District courts are invalidating patents at about a rate of 40%. There's clearly some disconnect between issuance and ultimate validity in the eyes of the courts. Mentioned earlier that one theory around this was that examiners simply weren't granted enough time, to adequately search prior art or fully get their heads wrapped around the domain. I'm not necessarily hearing that you think that's the case based on your experience. So if not, then why this big disconnect between issuance and ultimate validity? Like what's driving that?
Most judges have never been examiners. Most judges are not engineers. They're judges. They went to law school. They know how to deal with arguments. I think patent law is very unique in the sense that it's unlike, criminal law, business law, where you can look at a lot of the case law. Because that's one thing as examiners, we had to read the case law all the time. I was like, as I got some more senior as an examiner, we were given hours of time to read case law, which to read all these cases. And sometimes, when I would read the case law, I would see oversimplification of the technology. They're making associations that we're not allowed to make as examiners because of the statutes. We can't make those associations, but they're making associations because they're not governed by the same standard. When they're doing these cases, they're not looking at 101, 102, 103, 112. They're not governed by the manuals of patent examining procedure. They're governed by, federal law. PTAB is different. PTAB is within, there's certain part of PTAB is within the manuals of patent examination procedure. So it's following a certain standard. That's what makes PTAB so atrocious in terms of how it has been used.
The legal system itself bears some responsibility in the arena of solutions as well. Listen in as Louis shares some insights on conflict of interest and honest conversations that should be happening between inventors and their practitioners.
If the answer is you don't have an invention, you're right, it already exists. This is really that's the issue. This is not a good business model for you guys to tell the client, this is crap. You don't need to file a patent on that. It already exists. So nobody wants to say that, but frankly, that would be the honest answer in many cases. When you look at a product, don't spend your money on this. It already exists, or it's so incremental that it's not worth it. And the day people do that, you're going to have a lot less patents that are invalidated because they weren't, essentially they weren't valid in the first place. And believe me, I see a lot of those. I mean, I'm not joking. We see so much volume. I can tell you, it's not just bad patent attorneys. It's just the business incentives are misaligned, and that's what's creating a lot of these patents to be issued because your metric is not the same as the client, but the client doesn't know it. The client thinks that you have the same metric and the same goal, and you don't actually. Because we will do some prior art search and we'll find something and we'll tell the client, look, we can't take this under brokerage because you didn't invent anything. You should have done a prior art search prior to filing, and you would have saved yourself, especially when there's a portfolio with 5 to 10 patents, you would have saved yourself $500,000 probably in fees, if you had only spent $2,000 in search originally. So again, I'm not, I love patent. I mean, I'm part of the patent part, but I just don't like the fact that the business incentives are not properly aligned with what the client needs to get a meaningful patent at the end. And it reflects in the marketplace today, because, we can say all the bad things we want to say about the PTAB, about it being biased and all this, but the reality is, in a lot of cases, there was some relevant prior art, that made some of these patents invalid, the way they were drafted.
Outside of the present state of all of this ever-changing in a meaningful way, and we assume that the AIA and PTAB as we know them today remain the law of the land, in addition to having hard and honest conversations with practitioners, what can inventors do now to increase their odds of success should they end up facing an IPR sometime down the road? For an answer to this question, I once again sat down with Ashley.
So I think the best way to future-proof yourself is a few different things. One would be to make sure you're doing prior art searching. Don't rely on the patent office to find all the relevant art. They do have limited time. And so I would definitely engage with a practice such as Aurora or another practice to do prior art searching before you file your patent application, or at least before you convert it to a full utility application. I would also try to ensure that your claims capture one infringer, trying to avoid divided infringement, and your practitioner should know what this means. But from your, practical viewpoint, making sure that one entity would be doing all the steps of your claim. So if you can possibly think that two entities would have to work together to do your claimed process or to make your device, then the claim should be reworded to make it so it's just one party. I would also recommend that you always file continuation patent applications. What this means in practice in the United States is that when you are about to get an issued patent or any time during your patent application pendency, you can file additional claim sets that are based on the original patent application disclosure, the original specification, but these claim sets can pursue other types of inventions in your application. It can pursue broader or more narrow views of your invention, and by doing that, it allows you to always have a pending and open patent application family. So if one issued patent is challenged and your patent application is still pending, you can now still pursue additional claim sets that would hopefully avoid any prior art that was brought about in the IPR proceeding, in the challenge proceeding. And so I think these three things are very critical. And then lastly, think about how potential competitors are going to overcome your claims. What are the design arounds? And not that this is going to prevent any kind of IPR challenge, but it could help with an infringement proceeding where somehow somebody avoids your claims by doing some minor modifications. And so prior art searching, ensuring the claims capture one infringer, always have continuation applications pending, and then trying to think about how competitors may design around your claims. I think those are, four critical areas to just consider as you're working with practitioners and making sure you really own those decisions in your patent portfolio strategy.
Thanks, Ashley. That's a wrap for now. We hope this has been one part illuminating and at least two parts motivational. As we said at the opening, this is a very complex, high-stakes issue with many perspectives, and it's only with the benefit of a wider angle lens that we can hope to start chipping away at the problem with the most impactful solutions. Then hopefully this motivates you to take some action. Call your congressional reps, join an inventor advocacy group, have the tough conversations with your practitioner, draft more robust patents, spend the time to search prior art, and most importantly, do what you can to lend a voice to the issues that will define the innovation landscape for the next generation of inventors. All right, thanks for listening, and remember to check us out at aurorapatents.com for more great podcasts, blogs, and videos covering all things patent strategy. And if you're an agent or attorney and would like to be part of the discussion or an inventor with a topic you'd like to hear discussed, email us at podcast@aurorapatents.com. Do remember that this podcast does not constitute legal advice, and until next time, keep calm and patent on.
So, do you suppose you took that whole evil laugh and thunderclap thing a little too far?
No, not at all. You suppose saying PTAB out loud is anything like Candyman? Or if you say it in the mirror 5 times, you lose a patent?